Good morning, everybody. Thanks for joining us today for this webinar around the upcoming changes announced under the Windsor Framework Arrangement. Just to give you, first of all, a quick overview of what we hope to cover during today's webinar. We're going to start with a quick recap on how we got to where we are. I think this is always useful for companies just to kind of put a bit of an anchor, a bit of a focus point, so that we can kind of get the context behind the arrangements. We're then going to talk about Northern Ireland's unique position with dual market access for goods and the access that we have to both the internal UK market and the European Union market. Then, as per the focus area for today's webinar, we're going to look at the Windsor Framework, and we're going to look at particular the UK Internal Market Scheme, which is due to be fully implemented on or soon after the 31st of March 2025. We're going to look at the new arrangements that are going to be introduced for fast parcel operators and fast parcel movements from the same date. And we're going to consider the impact of the Windsor Framework on trade flows, different trading scenarios. I'm going to focus in on not at risk and at risk movements, because this is an area that I know from working directly with companies one-to-one over the last 4 or 5 years plus is an area that brings a lot of confusion for people. So we want to try and get that drilled down and that companies understand if their goods are at risk and not at risk. It's also very topical today that we're talking after the announcements of yesterday around trade measures, introduction of tariffs in the US for EU, UK origin goods, and then the retaliatory countermeasures that have been introduced by the EU. We're going to talk about that in terms of automatically at-risk goods. We're going to talk then a little bit about EU regulatory alignment here in Northern Ireland, and in particular around the general product safety regulations that apply to consumer goods. And we're going to then finish off with just a kind of key takeaways from today's event. I'm very conscious of the time that we have in today's event, and one of the notes that I put for myself before this is that there's been several presentations over the last couple of months, and there will be several presentations in the upcoming weeks from HMRC, by the Trader Support Service, Northern Ireland Customs Trade Academy, and others. And they very much go into the detail behind the processes for moving goods under internal market movement information, IMIs, about the SPIM processes and all of that type of thing. I'm going to talk more in terms of the reality behind the detail and what our unique trading arrangements actually mean, and what is the difference when you declare goods as not at risk and when you declare goods as at risk, where you can sell those goods and so forth. So we're going to go look at it that way. We've got a number of slides, as Marcus pointed out. These slides will be shared with all attendees thereafter, and the recording will also be available. And we will leave time to try and answer some questions at the end of it. We do know that this is very complicated. There is no single source at the moment to pull all the information that you require. If there was, there wouldn't be a need for consultants like myself working in the background. But this webinar should be seen as a gateway into the other supports that are available through InterTradeIreland and the Cross Border Trade Hub, where you can get tailored one-to-one support working directly with one of the consultants if your company is eligible to apply for that support thereafter. Okay, so let's start right back at the beginning of pre-2016, pre-2020. when the UK was the 28th member state of the European Union. That provided us with access with, at the time, about 515 million people living throughout the 28 member states of the European Union, and we were part of the EU's custom union and single market. That meant that essentially that goods could move freely. Once in free circulation in any member state of the European Union, they could move freely to the UK and vice versa. They could move from the UK to any other EU member state without the requirement for any customs declarations or the application of tariffs to be applied. The European Union has four core pillars: the free movement of goods, services, capital and people. And those were they also applied to UK citizens at that time when the UK was part of the European Union. And we also all applied the same broadly, same rules on VAT, customs and tariffs. The UK, as a member state of the European Union, couldn't negotiate their own trade deals. They negotiated collectively as part of that 28 member state union of countries. And then what happened on the 23rd of June 2016, we had here in the United Kingdom the vote on continued EU membership. And as we all know, and is now history, the UK voted to leave back then. Thereafter followed a period of about 3.5 years from the date the UK voted for Brexit in June 2016 to the end of January 2020, when the UK officially left the European Union and entered into a transition period until the 31st of December 2020. That transition period, the UK was no longer a member of the European Union, but continued to apply European Union rules and laws and continued to work under that in terms of trade. So what was the reason for the hold-up that prevented the UK from moving on from triggering Article 50, which was happening back in 2017, to leaving the European Union? And it was because reaching an agreement on the terms of the withdrawal proved to be a lot trickier than many in the UK government had predicted. We were told back at the time that it would be the easiest trade deal ever done, but even before we got to a trade deal between the UK and the European Union, we had a number of issues to work through. So the withdrawal agreement had three main areas that were covered out in it. And I often talk about this as a divorce settlement because that's what it kind of related to. It was a separation of the UK and the European Union. So the three main areas were the UK's financial contribution. As a member of the European Union, the UK had enjoyed the benefits of being a member state. It had also made commitments as a member state within the European Union, and those commitments and those benefits had to be paid for. Same way as in a divorce, you have a house and things like that that have to be settled. You might have signed up for car financing or whatever, and you need to work out who's going to pay what because you had both agreed to those terms when you were together. The second part of it was the protection of EU and UK citizens' rights. So that was UK citizens living in the European Union, settled within the European Union, and European citizens living in the UK. We had to work out would their settled status be confirmed? Did they have to leave because the four freedoms, the freedom of movement, would no longer apply to European citizens in the UK and vice versa? Again, who looked after the kids if we talk about it in terms of a divorce settlement? And the most tricky area that needed to be agreed within the withdrawal agreement, correctly or wrongly, we're not here to debate that today, was around a method to avoid a hard border on the island of Ireland. This was the area that had caused the most difficulty and brought the most challenges for the UK government on how they were going to work on this and what they could do to ensure that there was no requirement for physical infrastructure on the island of Ireland. And what did we end up with? We ended up with the Ireland Northern Ireland Protocol, the Protocol of Ireland Northern Ireland, the NI Protocol, multiple names. And this was part of the withdrawal agreement agreed between the European Union and the UK. It set out provisions on customs and trade and other areas specifically applicable to Northern Ireland, with the aim of avoiding a hard border between Northern Ireland and Ireland. The only physical land border that existed between the United Kingdom and the European Union was here on the island of Ireland. And we, depending on who you speak to, there is between 265 and 360, 370 border crossing points on the island of Ireland. To have physical infrastructure on all of those border crossing points was going to be impossible. There will be here people listening to the webinar, tune into the webinar today, like myself, who come from the border areas. I'm originally from Enniskillen in County Fermanagh. We know that the outcome would have been, as we had previously, unapproved roads, rerouting of commercial vehicles wanting to get over the border, because it just wouldn't have been possible to do it. So the Northern Ireland Protocol was announced, and it was agreed between the UK and the EU. My slides don't seem to be moving. 1 second. Sorry. There's 3 key areas within the Northern Ireland Protocol that are important when it comes to business and trade. The 2 areas would be customs arrangement and VAT. And the Northern Ireland Protocol, for those who want to read it, is only 60 odd pages long. It's not a big document, and it's easy to get your way through. So the customs arrangements are covered in Articles 4 and Article 5. VAT and excise is covered in Article 8 of the protocol. And then the political consent, was covered under Article 18. We also will have heard of Article 16. This is the ability to trigger Article 16, where there was a socio-economic or political implication of the application of the protocol in Northern Ireland that needed to be reviewed and negotiation carried out on. But the main areas for us today in terms of business are around customs arrangement and VAT. So what does this mean? Since 2021, 1st of January 2021, the UK left the European Union. The UK, including Northern Ireland, left the European Union. And as a result, we are no longer considered part of the European Union. However, because Articles 30 and 110 of the Treaty for the Function of the European Union continue to apply to and in the United Kingdom in respect of Northern Ireland, that means that there can be no quantitative restrictions on exports and imports between the European Union and Northern Ireland. As a result of that, Northern Ireland is part of the UK customs territory and therefore is assured of unfettered access to the rest of the UK market. We can benefit from UK free trade agreements on exports. We're going to try and cover that briefly later on. But also, because we continue to follow EU regulations on the trade of goods, there is no requirement for checks between Northern Ireland and the European Union. And because Articles 30 and 110 of the TFEU continue to apply to Northern Ireland, there is no tariffs, taxes, charges that wouldn't apply for trade between member states applicable for trade between Northern Ireland and the EU. That means that we have dual market access. So what does dual market access mean in the terms of Northern Ireland? Well, dual market access simply refers to the ability to access 2 markets without restrictions. This is unique in terms of Northern Ireland. We have free access to both the internal market of the United Kingdom as well as the 27 member states of the European Union single market for goods. We also have access to the EEA member states, Liechtenstein, Switzerland and Norway. Norway, Liechtenstein and Sweden, in there. And we have dual market access, which means that goods can move freely between Northern Ireland and those member states of the European Union and the EEA. Okay, so all sounds great, but how does it actually work? Are we part of the United Kingdom internal market, or are we part of the European Union single market? And this is a question that is frequently put to me. We are very much, as it states in Article 4 of the Northern Ireland Protocol, Northern Ireland is an integral part of the internal United Kingdom market. We remain part of the customs territory of the United Kingdom. However, we have access to the European Union single market for goods, because and to have that access, we have to have regulatory alliance, and then we have the continued treatment of Articles 30 and 110 of the TFEU. Again, this is very confusing. We understand that it's very, very confusing. So the UK, in the command paper of the previous government, the Conservative government, back in February 2024, when they put it out, they tried to show in a chart in Safeguarding the Union, both at the very beginning of the document and at the end of the document, what the difference was between Northern Ireland being part of the European Union single market, which it is often simply referred to as being part of the, continue to be part of the European single market, and the reality, which is that we have access to the European single market for goods. So that means that having access means just that. We have unfettered access to the UK internal market, and we have access to the EU single market for goods. But outside of that, we do not have any of the other benefits, or do not have any of the other administrative and financial implications that you would have as a European Union member state. So put this in a chart to kind of give an overview of how trade changed from the 1st of January 2021. So in terms of goods to and from Northern Ireland to the European Union, including Ireland, this has largely remained unaffected. And for a lot of companies, they see this. They can continue to buy from their suppliers in Ireland and elsewhere in the EU, and they can continue to sell to their suppliers in Ireland and the EU, as they did pre-Brexit. They can treat it as an an intra-community sale, the complete EC sales list, the purchasing company accounts for VAT under the reverse mechanism, all as it was pre-Brexit. Goods from Northern Ireland to GB remain mostly unaffected. So when we sell goods to the United Kingdom, to the market of Great Britain and the United Kingdom, it's mostly unaffected. There's a very small number of prohibited and restricted goods, Atlantic toothfish, tuna fish, mercury goods, torture goods, a very, very small 10 or 11 goods listed on it that require export declarations and import declarations and maybe some certificates, so, and some P&R goods, but it's very, very small. The rest of them can move mostly unaffected. That is, as per the commitment by the UK government, that Northern Ireland, as an integral part of the United Kingdom, would retain unfettered access to the European Union. Qualifying Northern Ireland goods is the only goods that this applies to, and I think that we cover this briefly later on. If we don't, I'll come back to it, Marcus, within the Q&A session. Goods from GB to NI. These were the movements that were impacted most as a result of the Northern Ireland Protocol, the Protocol on Ireland, Northern Ireland. So there's a requirement to complete import digital declarations and for sanitary, phytosanitary checks on goods moving into Northern Ireland from Great Britain. There is no requirement for export declarations in GB, no requirement for export safety and security declarations in Great Britain, but there is a requirement in Northern Ireland for import declarations and import safety and security declarations, ENS, which is a responsibility of the carrier. The UK government introduced to kind of mitigate against these risks and mitigate against these additional costs, the Trader Support Service, which is a free at source portal that allowed companies within the UK to complete their administrative obligations under the protocol at no cost. It's free to use system. Trading goods with rest of the world. In terms of exports, Northern Ireland benefits from UK free trade agreements. Our goods are considered as UK origin goods, and therefore we are not treated as EU origin goods. And again, we will try to briefly cover that because it's topical at the moment when we look at what's happening in world global markets with the US and implications of the US applying tariffs on goods and then the countermeasures that are being introduced by the EU and potentially in the future by the UK, but also potentially if there's a free trade agreement in the future between the US and the UK, albeit that I think that will be around technology more so than goods. And then we have additional requirements now in terms of goods moving from GB to NI via the Irish land bridge or vice versa, goods moving from continental Europe to Northern Ireland via GB, the Great Britain land bridge. These goods would require export declarations, import declarations, but they can move under transit accompanying documents, and that removes that requirement for opening and closing import and export declarations. So that was the Northern Ireland Protocol. As I say, it was negotiated and introduced from the 1st of January 2021 in most parts, or some parts of it were already in place on the 1st of January 2021. And did this cause any difficulties around internal trade within the United Kingdom, i.e. movements of goods from GB to Northern Ireland? And if we want to look at this and consider this, who did the Northern Ireland Protocol impact? What was the impacts of it? So essentially it impacted any companies that were based in Northern Ireland and buying from suppliers in Great Britain. It impacted the movement of goods into or through Northern Ireland. It impacted GB businesses who were selling to Northern Ireland or had operations in Northern Ireland where they were moving their own stock from GB warehouses to NI warehouses. It impacted EU businesses who had operations in Northern Ireland who may have been supplying into Great Britain or had branches in Northern Ireland. So it impacted a lot of businesses, and that was clear. And we had a situation where when we talk now about United Kingdom, which is obviously England, Scotland, Wales and Northern Ireland, but in terms of trade, we talk about GB, Great Britain, and we talk about United Kingdom excluding Northern Ireland because of our unique trading arrangements. And did it cause difficulties? It did cause some difficulties. So back in February 2023, just over 2 years ago, it was announced that the Windsor Framework had been negotiated between the UK and the European Union in an attempt to resolve those issues around internal trade. I'm just going to take a quick sip of some water here. So the Windsor Framework in terms of business, it covered a number of areas. It provided dispensation in the first place for the movement of retail sanitary phytosanitary goods that were for end consumption in Northern Ireland by trusted traders. And this is known as the Northern Ireland Retail Movement Scheme. And we're not going to cover this today, but just to highlight it, because this is one of the main areas that was controversial at the time. There was the potential because of the removal of prohibited and restricted goods. You cannot move P&R, prohibited and restricted goods, from a third country, which is what the UK was now considered in terms of the European Union, and vice versa. The European Union is considered by the United Kingdom. You cannot move P&R goods, which include chilled meats and things like that, chilled sausages, and different products that you would commonly see prepackaged on shelves throughout Ireland, throughout Northern Ireland, throughout the United Kingdom. You could not move them from outside the European Union in. So this was causing difficulties for our supermarkets, the big stores, the Asda's, the Tesco's, the Sainsbury's, the Marks and Spencer's. You had the potential where a product that was on the shelf in Great Britain, in Liverpool or Manchester or London, couldn't be purchased on a shelf here in Northern Ireland. Now, we did have grace periods. We did have STAMI, which was a short time, a stopgap kind of solution for this. But this was one of the solutions that was introduced under the Windsor Framework. It was the Northern Ireland Retail Movement Scheme that essentially allowed the same products to be sold on the shelves in Great Britain to be sold on the shelves here in Northern Ireland, and you will see them labelled as not for EU. And that simply means that they cannot be sold within the European Union because they would have been goods that were restricted, such as chilled meats, or because they haven't gone through the export health certificate requirements and the other requirements that you would normally have to undertake if you're moving SPS goods into the European Union from outside. The big one that we're concentrating on within this event is around the new rules for the UK Internal Market Scheme. The precursor to the UK Internal Market Scheme was the UK Trader Support, UK Trader Scheme. The UK Trader Scheme removed the tariffs, the EU third country tariffs on goods moving into Northern Ireland from Great Britain that were not at risk of entering the European Union. However, you still had to meet the requirement of completing import declarations when moving these goods. The UK Internal Market Scheme went further than the removal of the tariffs. It also meant that there would be no longer requirement to complete customs declarations, supplementary declarations for not at risk goods being moved by authorised UK Internal Market Scheme companies into Northern Ireland from Great Britain that were not at risk of entering the European Union. Fast parcel movements had always been treated differently. Again, this was under an agreed grace period for 3 months, I think, back in 2021, to give the fast parcel operators time to get their systems into place. But then that had been unilaterally extended by the UK up until the Windsor Framework was agreed, and essentially meant that the same arrangements that were required for freight movements into Northern Ireland would apply to parcel movements, fast parcel movements, which had essentially been given free movement because of their size and weight, where there was no requirement to complete customs declarations and no requirement to pay tariffs. Some of you may recall that when you went on the UK Gov website and looked for parcel movements, it would have told you to keep track of all parcel movements that you bring from GB to NI, because you will have to retrospectively declare these via the Trader Support Service at a point in the future. The Windsor Framework not only removed that requirement to retrospectively declare previous fast parcel movements, but it also gave us a further 18 months, which was extended out by 6 months from the 1st of October till the 31st of March, period where these parcels could continue to move without the requirement for customs declarations or the payment of tariffs. It also brought into place new arrangements for duty reimbursement scheme. There was the ability to request reimbursements for overpayment of duty through other kind of generic standard schemes, but they brought in a specific one where if you were able to provide evidence that the goods that you'd moved from Great Britain to Northern Ireland had remained within the United Kingdom, you could then apply to be reimbursed any duty that you had paid on those goods previously. The duty reimbursement scheme also allowed you to request that duty you'd been paid moved to your de minimis allowance, your waiver account instead, and you were reimbursed for that duty. And also brought in arrangements for steel goods with tariff rate quotas moving from Great Britain to Northern Ireland under Category 7 and 17 that because of the Ukraine war had been moved to global tariffs pools instead of country-specific pools, that there was a quota available specifically for UK origin steel. So those were the main ones. The other ones that you would have heard of at the time, the big one was the introduction of the Stormont Break. Whilst we had Article 16 within the original Northern Ireland Protocol, the Stormont Break is when 30 plus MLAs from across two political parties request that the UK government suspend the application of amended or new provisions of EU law due to the fact that they think they're going to have significant and lasting impact specific to the everyday lives of communities in Northern Ireland. We've seen this, an attempt to apply this in the last couple of months in terms of labelling for chemical products, but that didn't actually get any further than being the request we made to the UK government. And it has to be very, very specific that the Stormont Break can be used, and it will be exceptional circumstances where if the UK decide that those new or amended laws or provisions are not going to apply in Northern Ireland, it is likely that the EU will counterbalance that in some way. So, UK Internal Market Scheme. This is what we're going to look at today and talk about today. Many of you will have applied previously for the UK Trader Scheme. The application process was done online. You then saved it and then you emailed it through to HMRC through a UK Trader Scheme specified email address. The UK Internal Market Scheme application is done via your government gateway account. The application is where you must provide information to justify for self-certifying. That's what you're doing. You're self-certifying within the UK Internal Market Scheme that your goods are not at risk of entering the European Union, i.e. that you only sell entirely, wholly, purely within the United Kingdom internal market. This is much easier for physical stores. So if I have a store here in Downpatrick, that I bring my stock in from GB suppliers, that I only sell the stock physically in my store in Downpatrick. And if I do sell online, my e-commerce site only allows you to place an order and get delivery on a BT postcode. It becomes much more difficult when you're buying, when you're selling B2B, business to business, or when you are operating an e-commerce option where you make your goods available for sale not only within the United Kingdom, but also to customers in Ireland or maybe across the European Union. But once you're certified, authorised under the UK Internal Market Scheme, again, you're self-certifying. HMRC are not telling you that your goods are not at risk of entering the European Union. As part of the application process, you tick 9 declarations, 9 individual declarations, indicating that you will not use your authorisation to move goods that are destined for or at risk of entering the European Union. Your letter of authorisation also tells you when you can and when you cannot use your authorisation. But for those purely, wholly, entirely internal movements of not at risk goods. UK Internal Market Scheme allows you to complete, once fully implemented, on or soon after the 31st of March 2025, reduced data set, 21 pieces of data fields. Some of them will be pre-populated, vast majority of them will be pre-populated by your supplier, rather than having to complete the potentially 80 plus fields that you need to complete within a supplementary declaration. So instead of completing a supplementary declaration or an import declaration, you complete what's known as an IMI, Internal Market Movement Information, and it's through the SPIM, the Simplified Process for Internal Market Movements process. We talk about that, previously known as the green lane, but there won't be a green and red, a physical green and red lane for movement of goods. It's not like when we go through the airport and we see green lane, nothing to declare, red lane, goods to declare, and then the checks are carried out on the goods going through the red lane, and only intelligent based checks carried out on the green lane. There won't be any physical separation of goods when they're coming via the ports. It will all be done virtually, and that's why we talk about internal market movements and at-risk movements, or internal market movements and red lanes. Some of the other things that would change within the UK Internal Market Scheme from the UK Trader Scheme was that there was additional requirements for commercial processors, and a commercial processor, there was a turnover threshold placed on it of 500,000, and this was increased to 2 million under UK Internal Market Scheme, under UKIMS, and then we had some exemptions for production purposes, and we're going to cover those later on. So with the reduced data sets, you'll see the fields that are mandatory. Anybody who attended the presentation over the last couple of weeks for InterTradeIreland by HMRC will be aware of this. Anybody who has attended any of the Trader Support Service Northern Ireland Customs Trade Academy webinars on introduction of SPIM and IMI will be aware of the data fields that are required both for not at risk IMI movements and at risk movements, and that is commodity codes, country of origin, value of the goods, type of packaging of the goods, and the weight of the goods that are coming in. Also introduced under the Windsor Framework arrangements, and it will be introduced in line in conjunction with the introduction of the IMI, not at risk movement arrangements, and the at risk movement arrangements, is these changes for GB/NI parcel movement. To just clarify once again, there will never be customs for consumer to consumer movements of goods. There will never be customs requirement on GB businesses selling and sending directly products to consumers in Northern Ireland. Those goods will continue to move free of customs and free of tariffs, and that is where Northern Ireland is in a unique position that we can receive parcels from both GB, the UK and the EU free of customs and free of tariffs. There will be the introduction of new requirements for B2B movements coming from Northern Ireland. B2B movements that are not at risk, i.e. the company, either the importer can be the supplier or the receiver in Northern Ireland, is UKIMS authorised. They are recorded as the importer of record for these movements. They are self-certifying that these goods are not at risk of entering the European Union market. These goods will be able to move under the new simplified process for internal market movements once implemented. And instead of requiring a customs declaration, they will complete an IMI, internal market movement information, with that reduced data set of information required and no tariffs applied. Whilst for goods that are at risk of entering the European Union from or soon after the 31st of March, there will be a requirement for import declarations and there will be the application of EU tariffs unless preferential origin, return goods relief or waivers are used, or other reliefs are used or being claimed by the importer to remove or reduce or waive those associated tariffs. So when the new arrangements are introduced under UKIMS for at-risk and not-at-risk movements, in line with that, the arrangements will be introduced for fast parcel movements, with the difference being that fast parcel operators are not expected to provide an option for you to self-declare via TSS the way that you do for freight movements. The fast parcel operator will be completing the import declarations for you as part of their door-to-door service. If your goods are not at risk, you provided them with your UKIMS authorization, you confirm that your goods are not at risk, they will require from either you or the supplier the reduced data set of information. For at-risk movements, they will complete for you an import declaration. You can request that preferential origin is applied if the goods originate in or have been manufactured within the UK and meet preferential origin requirements under the UK-EU Trade and Cooperation Agreement. You can request return goods relief if you can provide evidence that the goods were previously in free circulation within the European Union prior to being moved to Great Britain and onward to Northern Ireland. Or you can ask for them to waive the tariffs using your digital waiver account, which will be accessed by them via your EORI number, your Economic Operator Registration Information Number. And that will, the same way as you use NIAID, Northern Ireland aid, de minimis aid, for your freight movements, you can have that remove the associated tariffs from your parcel movements. All of this is all around the idea of at-risk and not at risk movements. And this is the area that is most complicated for companies trying to determine if their goods are at risk or not at risk. It is extremely confusing for companies, and I appreciate that. So under the Northern Ireland Protocol, and pre-Northern Ireland Protocol, from June, July 2020, the EU were insisting at that time that all goods moving from Great Britain to Northern Ireland would be considered as at risk. In other words, EU third country tariffs would apply to all goods going from Great Britain to Northern Ireland. The negotiations that took place between the UK and EU, Michael Gove at the time and Šefčovič at the time, around the ability to operate the Northern Ireland Protocol in principle, that came out around early December 2020, had brought some changes around that. So it was the introduction of the UK Trader Scheme, where companies were able to self-certify that the goods were not at risk of entering the European Union. There was exemptions that I talked about for certain production purposes and commercial processors, and there was a turnover threshold of 500,000 introduced at that time. And that meant that there was options for companies to declare their goods as not at risk. But what does it mean when you say at risk and not at risk? It's completely unique to Northern Ireland. At risk, not at risk. Not at risk goods, as I give the easy example of a store in Northern Ireland physically selling from bricks and mortar conventional store product. You come in, you walk into the shop, you purchase the product, you take it out with you. It doesn't matter if you bring it then across the border into Dundalk or Monaghan or wherever else. You've bought the product in Northern Ireland. Equally, if you operate an e-commerce site, you can provide as your reason for your goods being not at risk. My products are only sold online. If you can provide a BT postcode or a UK postcode, we will only deliver to these. So that is that at risk, entirely, wholly, purely for sale within the Northern Ireland and the UK internal market. Commercial processed goods were automatically deemed at risk, and you see this under Article 5 of the Northern Ireland Protocol. Again, this confuses a lot of companies. I see companies who have completed applications to the UK Internal Market Scheme where they've said, We bring in raw materials. We do not sell these raw materials. We process these raw materials and we turn them into another product which is worth several times the value of the raw materials combined. If you commercially process goods in Northern Ireland, they were automatically deemed as being at risk. However, under UKIMS, you have now got the ability up to a turnover threshold of 2 million. This is additional eligibility criteria on top of the requirement that you only sell your goods internally within the United Kingdom. That if you're a commercial processor, only selling your goods within the United Kingdom, if your turnover is less than 2 million, you have the ability with evidence to declare those goods as not at risk. However, if you are a commercial processor with a turnover of 2.1 million, even if you only sell your products within the internal United Kingdom market, you cannot declare any of the materials that you bring in for processing and then sale within your final product as not at risk. There has been legal challenges around this by companies that have said that they will take on, they will sign legal declarations stating that they only sell within the United Kingdom and so forth. But as it stands today, the rule is if you're over that 2 million threshold, irrespective of where you sell your products or not, they are deemed as automatically at risk. Okay, so we've got there's exemptions then for certain products. So the main one that I will see is around construction. You bring in goods, materials, you or one further entity that will be used in the construction of a permanent structure within Northern Ireland. By the way, I sought clarification on this, and it is Northern Ireland, not the United Kingdom. Other ends of it, you can see food for sale to end consumers in the UK. The construction exemption is for goods that are brought in that will form a permanent part of a structure in Northern Ireland. So an example I could give of this is I have a client who brings in stainless steel and they bring in other products that they then use for the production of air vent systems and clean air systems and so forth. They then are installed permanently into factories and so forth here in Northern Ireland. If they can identify those goods as being purely, wholly, entirely, 100% at the point of import for that one customer and that one project, they can declare those goods as not at risk of entering the EU because of that exemption. Food for sale to end consumers, healthcare, non-profit, where if you're bringing in goods that you manufacture into a product that you then don't sell, but you make available under your charitable status to your users, animal feed that is brought in by you and one further entity for use within farms here in Northern Ireland. This is where it gets more and more complicated, especially at the moment when we're talking about US introducing tariffs and then countermeasures being taken by the EU, as was announced yesterday. Goods that have safeguarding tariffs attached are automatically deemed at risk of entering the EU. So you will hear people talk about standard goods, category 2 goods and category 1 goods. Category 1 goods are goods that have anti-dumping, safeguarding or tariff rate quotas or other safeguarding or countervailing measures attached to it, and they are automatically deemed at risk. Easy example. I have a client who brings in branded products. They bring in mugs. I could ask them to produce for me Fortior Insight mugs that I'm going to provide to my client base here in Northern Ireland. Porcelain and ceramic China mugs coming from China, i.e. China origin, even if they are coming via a UK distributor, have anti-dumping duty attached to it. Because they have anti-dumping duty attached to it, they are considered as automatically being at risk of entering the European Union. I can't, therefore, declare them under the new simplified process for internal market movements. As soon as I put in the country of origin of China with the specific commodity code, they will be rejected going through that. Therefore, my options are to either pay the tariffs and then reclaim them through the duty reimbursement scheme by providing evidence that the mugs were for Fortior Insight or another company here in Northern Ireland, or I waive the associated tariffs, which means that I don't physically pay the tariffs applied, but I reduce my €300,000 de minimis allowance balance by the applicable duty, and then I can move the goods in. So that is worth considering. When I'm bringing in goods from the rest of the world to Northern Ireland, if the EU tariff is 3% or higher than the UK tariff, they are automatically deemed at risk as well. So those are times when goods are automatically deemed at being at risk. This is an extract from direct correspondence between myself and Trader Support Service and HMRC when they came back to me with a request that I put in specifically around a company here in Northern Ireland. It's often said to me, 99% of everything that we sell is within the UK. We only sell 1% to customers within the Republic of Ireland or elsewhere in the European Union. If you make available for sale, if you sell 1%, 2% of your goods to the European Union, if you do not know what the point of import, the final destination of the goods that you're bringing in, they are deemed to be at risk of entering the EU, and you cannot declare those goods under not at risk under UK Internal Market Scheme, and once introduced and fully implemented, the simplified process for internal market movements. When you sell goods into the European Union, you complete EC sales list. It's not Intrastat. EC sales list applies to all sales within the European Union. It's the same with your intra-community supply for VAT purposes, or for if you're selling to consumers when you use the one-stop shop for those distance sales. You are providing evidence that your goods are being sold into the European Union. If you do not know at the point of import where you're going to sell the goods, you cannot declare them as not at risk. That is, I can see from the events that both Trader Support Service and HMRC have done recently, this has been clarified and clearly stated more and more. So the timeline for the introduction of these new arrangements, we are told that companies should be prepared by the 31st of March 2025. So today is the 12th, so we've just got just over 2 weeks until the 31st of March. Monday fortnight is, 3 weeks is the 31st of March. And we are told to be prepared for then. That doesn't mean that it will come in automatically on the 1st of April. It needs to be ratified by both the UK and the EU, so it may take a couple of weeks, or maybe the 1st of May that it comes into play, but it will come into play. And it's the same with the arrangements for fast parcel movements. They were originally due to come in on the 1st of October last year, 2024. We got a 6-month extension, and that was due to giving time for fast parcel operators to get ready, because you may recall at that time fast parcel operators were saying that they would automatically charge EU tariffs and then you would have to claim it back. We now know that you're able to use your waiver, you're allowed to use preferential origin and other ways to remove associated tariffs. So under the Windsor framework, what has changed from the arrangements that we've seen with the Northern Ireland Protocol? Goods to and from Northern Ireland and the European Union can continue to move unaffected, unless you declare your goods as being not at risk when you move them in from Great Britain or the rest of the world. If you declare goods at not at risk when you bring it in from the rest of the world and therefore pay UK tariffs, or when you bring it in from Great Britain where you have not completed import declaration, you've completed an internal market movement information, those goods cannot be sold within the European Union. So just be in mind in that. If you declare the goods as not at risk, you're limiting where you can sell your goods. Goods from Northern Ireland to GB continue to move mostly unaffected, apart from the prohibited restricted goods that we talked about before. Non-at-risk goods moving from GB to NI are light touch. That means that the goods can move into Northern Ireland under the new simplified process for internal market movements, but those goods are being declared as not at risk of entering the EU, and that means they are in free circulation within the UK only. They cannot be sold to the EU, customers in the EU. And part of your requirement and your obligations under the UK Internal Market Scheme is that you hold evidence for 5 years to show that your goods have remained within the internal United Kingdom market, which you must present if requested. At-risk goods moving from GB to NI, there's no change. In terms of freight movements, you continue to do what you're doing now, completing import declarations, or if you use the TSS, you complete supplementary declarations. For fast parcel movements coming in, you will have new customs obligations introduced. However, unlike freight movements, the fast parcel operator will complete these customs declarations on your behalf, and you can use your waivers, preferential origin, or whatever, and that will be completed. So you will not be completing declarations for them. We do not expect any fast parcel operators to use TSS to clear the goods that they're bringing in for you. They can do, but we don't expect them to. Rest of the world, Northern Ireland, we continue to benefit from UK free trade agreements on exports. But as I've already pointed out, in terms of imports, any safeguarding tariffs make good automatically at risk. If the tariffs, EU tariff is 3% or higher than the UK tariff, they're automatically at risk. And if you sell or make your goods available for sale into the EU, or you're a commercial processor with turnover of more than 2 million, EU tariffs will apply. And transit movements will continue to move as they did before. Very conscious of time. I know that I'm an hour into this. I just want to cover through now the regulatory element of it in terms of general product safety regulations, but also in general around conformity marking, because I know this comes up. So the UK continues to be bound, or sorry, Northern Ireland continues to be bound, and we are aligned with the EU in terms of regulatory alignment. That means our goods need to continue to meet EU standards. Typically, that we were talking about before, that was in terms of the CE mark on goods that had to be CE marked. And when the UK left the European Union, they introduced their own conformity marking, UCA mark, the UK CA mark. The UCA mark was not deemed legally satisfactory within Northern Ireland. Products that only had the UCA mark did not meet the conformity requirements of the EU, and therefore also required the CE mark. Now, you can also have the CE UK NI mark. The CE UK NI mark means that the goods have been accredited by a UK-based certification company. Those goods are in free circulation. Those goods can be sold within the UK, Northern Ireland, and Great Britain. But when they have the CE UK NI mark, they cannot be sold into the European Union. The only goods that can be sold into the European Union, once if they require CE marking, are goods with the CE marking. Qualified Northern Ireland goods. I said I would cover this very briefly, and I will. The unfettered access, the dual market access that Northern Ireland has only applies to Northern Ireland. I'm often asked by companies in the Republic of Ireland and elsewhere, what does the Windsor Framework Northern Ireland Protocol mean to me? The Windsor Framework Northern Ireland Protocol means to you that you can buy from and you can sell to customers in Northern Ireland and suppliers in Northern Ireland. That's it. You do not get unfettered access to the UK internal market if you're an EU company. And so that only applies to qualifying Northern Ireland goods. Qualifying Northern Ireland goods are goods that were physically located in Northern Ireland at the point of sale and that were in free circulation in Northern Ireland. This means that those goods were, when the sale came in, the goods were physically located here. They weren't under customs special procedures. They weren't in a customs warehouse. They're also goods that are processed, commercially processed Northern Ireland goods. Northern Ireland, if the materials that made up the commercially processed Northern Ireland good, qualifying Northern Ireland good, were in free circulation in Northern Ireland at the point of processing, those goods as a finished product can then be sold as a qualifying Northern Ireland good. If you are in the Republic of Ireland and you get a sale from Great Britain and you move those products from Ireland or elsewhere in the EU into Northern Ireland and then from Northern Ireland into GB, that's circumvention. Your goods are not qualifying Northern Ireland goods. There is additional requirements for sanitary, phytosanitary goods, agri-foods. They must come from registered processors or fulfillment distribution centres. Okay. General Product Safety Regulations introduced on the 13th of December, 13th of December last year. General Product Safety Regulations applied to consumer goods. And essentially, the GPSO were brought in by the EU to protect EU consumers from faulty, dangerous goods entering the European Union and being sold directly to consumers. Consumer goods are goods that our consumers buy to satisfy their needs, and it's everything from clothing and furniture to electronics. They are not raw materials. They are finished products. They apply to finished products. When we heard about GPSR, a lot of the press that we got around here was the requirement under GPSR that companies within GB required, and elsewhere in the rest of the world, required an authorised representative within the European Union or Northern Ireland in order to be able to sell their goods into the EU single market and to Northern Ireland. Because Northern Ireland is aligned with the EU, the same rules applied for Northern Ireland as they do for the European Union. And that means that there is an authorised representative required for non-European, non-Northern Ireland manufacturers. Authorised representative is a written mandate. If they do not have established premises within the EU or Northern Ireland, they have a requirement for an authorised representative. Authorised representative is a written mandate between the manufacturer and that they will be responsible for the reporting. They will be the point of contact for consumers within the EU and so forth. So a lot of stories we heard about were about Etsy suppliers in Cornwall and elsewhere in the GB who were no longer able to supply to customers in Northern Ireland because they were outside of the European Union and they required an authorised representative, and there was ridiculous charges being put on companies to get an authorised representative here in either NI or EU. Northern Ireland companies can act as an authorised representative for GB and other rest of world manufacturers. So you need to be aware of what your role is within General Product Safety Regulations and the consumer goods. If you're a manufacturer, you meet the requirement. As a Northern Ireland company, you do not require an authorised representative. I know that there's been some consultants who've said that you do require an authorised representative within an EU member state. We don't. Being in Northern Ireland is sufficient. We can act as an authorised representative for other non-EU manufacturers. If the manufacturer is outside of the EU, you become an importer. You can also take on that role of authorised representative. You can take on that role as any economic operator part in the supply chain. But if your supplier is within the EU or Northern Ireland, you are a distributor for those goods, and they have the obligations under that manufacturer to ensure that risks are assessed and highlighted, that any concerns around safety issues are reported through the EU safety check system and so forth. Spoke for a good hour and 10 minutes. So what is the key takeaways, hopefully, from today's webinar? I know that we've covered a lot. As I said, this is a very high-level discussion. It is at the very beginning, hopefully, of your relationship with InterTradeIreland. And if you're eligible, I would encourage companies to seek one-to-one tailored consultancy support for your specific company requirements, your supply chain, your needs, and so forth like that. But the key takeaways, if you do nothing else from today's seminar, is check, have you signed up for the UK Internal Market Scheme? I would encourage all companies, including cross-border traders, to sign up for the UK Internal Market Scheme so that you have the ability to declare goods that you bring in for internal business use, including consumables, as not at risk. This means that if you're in Northern Ireland and you purchase a vehicle within GB, or if you purchase consumables, office consumables, photocopying paper, inks, stationery, computers, furnishings, any products that you bring in from Great Britain for internal business use, unless you are approved under the UK Internal Market Scheme, you will not be able to declare those goods as not at risk of entering the EU, and therefore you will continue to have to complete import declarations and either pay or waive the associated tariffs. If you are registered for UKIMS, make sure that you and your business and the goods you move meet the criteria to declare goods as not at risk. Remember, you are self-certifying. The application process, I've gone through it recently with a client company. It has been streamlined. It is more specific. There is more clarity in it. But a lot of companies have said to me, UK government, HMRC have told us our goods are not at risk. No, they haven't. You are self-certifying through a trusted trader scheme that your goods are not at risk of entering the EU. You are ticking 9 declarations through your government gateway account to say that you understand what you're signing up to. You get your letter of authorization, which states when you can and when you cannot use your authorization. You are told that you must hold for 5 years, which you produce on demand, evidence that your goods remain within the United Kingdom internal market. You are not, and you have never been told by HMRC that that your goods are not at risk of entering the European Union. So be very, very aware of that. It's up to you to ensure that you meet the requirements of it. I know of companies, commercial processors with turnovers of 30, 40, 50 million who have gone through the application process for UKIMS and have got a letter of offer. Their letter of offer means very little. It means nothing in terms of the goods that they bring in for processing and then onward sale. They can't use it. They have stated clearly that they understood the rules, the eligibility criteria for commercial processors, when they can and when they can't use it. So be very aware of that. Be aware that at risk and not at risk applies to both movements you make from Great Britain to Northern Ireland and from the rest of the world to Northern Ireland. Why is that important? If you bring import goods in from the rest of the world, your customs agent will ask you if your goods are at risk or not. If you sell your goods into the EU, your goods are at risk. If the tariff associated with the commodity code and the country of origin is 3% or higher, the EU tariff than the UK tariff, they are automatically at risk. If there is safeguarding tariffs, trade measures applied, they are automatically at risk. So you will apply EU tariffs as opposed to UK tariffs. For internal market movements, GB10I movements, UKIMS authorization means the difference between completing import declarations and completing IMEs, but be aware it applies to both GBNI and rest of world NI movements. There is no requirement to complete import declarations for goods moving from the European Union to Northern Ireland. Just also be aware that whilst if you declare your goods under UKIMS is not at risk, means you cannot sell any goods that you bring in from Great Britain or rest of the world to customers in the EU. That doesn't prevent you from having suppliers within the EU. You can bring the products into Northern Ireland as long as you're selling them. You're said that you're an internal trader, but you can still purchase from suppliers within the EU unfettered, even if you're UKIMS approved. Consider the impact of the new arrangements for fast parcel movements. I have worked with companies in the past who have never had to complete a declaration on TSS, have never had to waive tariffs through their de minimis allowance, because everything that they have brought in has come via parcel movement. So for them, Brexit essentially happens on or soon after the 31st of March 2025, when the new arrangements are introduced for fast parcel operators. So they need to be aware that how many parcels they're getting in. Have they spoken to their suppliers? Have they explained to the suppliers and the fast parcel operators that they use to move goods on their behalf from GB to NI if their goods are at risk or not at risk? Do they know the commodity code for the goods that they're bringing in? Do they know the country of origin? Are they able to provide this information? Because it could lead to delays. What costs that fast parcel operators are going to charge for completing IMEs and completing import declarations, we don't know. It's a commercial decision. I have heard companies quote everything from £5 for an IME or a commercial import declaration to £20. So shop around. Is your fast parcel operator still going to offer that service B2B? What's the associated cost going to be once these requirements are in place? And with general product safety regulations, I know that we went through them very, very quickly, but consider if the goods that you bring in are consumer goods. Do you sell goods directly to end consumers? If you are B2B, you must also consider if the goods that you bring in B2B could end up with end consumers. Is your manufacturer of these products in the EU or outside the EU? Are you aware of your obligations under GPSR? Because every economic operator in the supply chain have obligations under GPSR. So be very aware of that as well. It's in place. Even if your goods are not at risk of entering the EU, GPSR applies to Northern Ireland. So we've covered lots, Marcus. Hopefully we've got through it. I know that you've got a couple of slides now that you want to finish off here with. So I'll mute myself and let you go on ahead.
Yes, thank you very much, Jonathan. That was an excellent summary of what can be some quite detailed and quite complex information. And before I just touch upon a couple of slides here just about how InterTradeIreland can help you in your business, I just want to remind everyone, please use the chat function if you have any questions, and we will endeavour to get through as many of them as possible. I see we've already got a number of questions that have come in. If anyone has any other questions, please do add them in. So just to make you aware very quickly, how can we help you and your business relating to some of the content that's been discussed today. So at InterTradeIreland, we run a program called the Trade Hub, which is basically an online knowledge base where we have easy to understand digital content on a large range of customs, VAT, regulation and employment areas, including at risk, UKIMS, GPSR, you name it. We have got easy to understand advice and guidance that is reviewed regularly by some of our leading consultants. In terms of, Jonathan mentioned a fully funded consultancy support. So subject to some basic eligibility criteria, if you're on the call today, we would strongly encourage you to consider applying for some fully funded one-to-one consultancy with one of our approved consultants. This consultancy can be up to the value of £2,000 and can be used to help in 4 areas: customs, VAT, regulation and employment. So if you're unsure whether your goods are at risk, what you need to do regarding UKIMS, GPSR, parcels or VAT, any of those areas, you can get a specialist consultant, well, Jonathan or one of our other consultants, to help to provide fully funded one-to-one support. The link is in the slides, which we shared afterwards. We will also include the link in the email along with the slides. If you have any questions today, please feel free to reach out to us, either myself or my colleague Christine, and we'd be more than happy to speak with you privately as well offline to discuss any questions you might have. And last but not least, before we just move on to the Q&A, I just want to make you aware of another event we're running. This will be an in-person event on the 26th of March up at the Guildhall in Derry, Londonderry. This will be a sort of half-day sort of morning event, and the key thing is it's about just trying to give you sort of key practical tips on how on trading cross-border, increasing your export potential. So we will have representatives from not just ourselves but other funding bodies there. We will have some of our consultants and leading experts in the field who will be able to give practical tips and insights and just help you expand your trade cross-border and beyond. We will also have a number of local SMEs who will give their experience of exporting in a practical sense, and what to do and what not to do as well. So I would strongly encourage anyone who, if you are anywhere near the Guildhall in Derry, Londonderry at the 26th of March, to come along to the event. You will hear, as I say, hear from a number of speakers about just practical tips as to how you can to grow your business.